are protected from discrimination in employment and housing. I'm a member of our community. I'm a happily married lesbian, and I'm happy to report that we're protected from discrimination due to sexual orientation and gender identity in both employment and housing. We're also protected from discrimination due to other protected classes that we belong to, such as, for example, our race. And you're going to hear more about protected classes throughout this webinar, but for right now, just know that all of us belong to multiple protected classes. Just a little roadmap for our webinar today. Alexis is going to cover employment discrimination. And then Emily, Mike, and I are going to divide up housing discrimination. Emily's going to give you a big overview of housing discrimination, including in Tennessee. I'm going to talk about the framework for fair housing protections for sexual orientation and gender identity at the federal level. And Mike's going to talk about Virginia fair housing law particularly. At the end of all that, we will take some questions. So just want you to keep in mind again that sexual orientation and gender identity are protected classes in the employment setting and also the housing setting. And know that you can contact any of our organizations for assistance once you get done with the webinar if you think you're being discriminated against, and we'll provide our contact information throughout in the slides, and then you'll have those later on to refer back to. I think now we're going to go to Alexis for employment discrimination.
Thank you, Marty, and thank you, Autumn. My name is Alexis Tehinchy. I am an attorney practicing in the Tri-Cities area. I practice in both Tennessee and Virginia. My office is in Kingsport. And I do primarily employment law in my work. And Autumn, you can go ahead to the next slide. So the main federal law that comes into play in employment discrimination cases, particularly involving sexual orientation and gender identity, is Title VII, the Civil Rights Act of 1964. And Title VII prohibits discrimination based on a number of protected classes, one of those being sex. Marty just spoke a little bit about other protected classes. Title VII also considers protected classes to be religion, race, national origin. There are other federal laws that cover disabilities and age discriminations. There are a number of protected classes under federal law, but of course we're here today primarily to talk about sex discrimination and subcategories that have fallen under sex discrimination. I'm getting feedback that not everyone can hear me. Let me just check my microphone for a moment.
It's a little quiet.
Okay.
We have clarity, but not volume, I think.
I'm sorry, what was that, Mike?
There's clarity, but not volume.
Okay, I'm not sure how to fix that. I'll try to speak a little more loudly and a little closer to my microphone. Is that any better?
Yeah, thanks, Alexis.
Okay, all right. So protected classes under Title VII, a protected class is sex. So the language of the statute prohibits discrimination because of sex. That is the statutory language. And the Supreme Court and other courts over the years have interpreted because of sex to include sexual orientation, sex stereotyping, and transgender status and gender identity. And we don't really have the time today to get into the weeds of each of these cases, but I have listed the Supreme Court cases there. If you're inclined to go look them up, you're certainly welcome to do that. So it's clear at this point that an employer cannot discriminate against an employee on the basis of sexual orientation, sex stereotyping, which includes things like discrimination because an employee does not meet the employer's ideas of what a certain person of a certain gender should look like or behave like, and then transgender status and gender identity. The law, Title VII, also prohibits retaliation for complaining about illegal discrimination. So on behalf of yourself or on behalf of someone else, if you go to HR or if you go to management and say, I believe that there's illegal discrimination happening here, your employer cannot take an adverse action against you because you made that complaint. Autumn, you can move to the next slide. So who is covered under Title VII? Title VII, the federal law, only applies to employers who employ at least 15 employees. So unfortunately, this means that if you work for a very small employer, you may not be covered under the law. It does cover both private and public employers. If you work for a government employer, you are covered by Title VII, and it also applies to labor unions. You can move to the next slide. So what constitutes discrimination? Discrimination includes harassment, and harassment is sort of broken out into two different categories. There's something called quid pro quo harassment, which is this, then that. So it's an example of that would be if you want to get a promotion, you have to do X. Or if you do not do Y, you will be terminated. If you are given that sort of ultimatum based on your sexual orientation or gender identity, that is unlawful discrimination. It also includes something that we talk about a lot and that we hear about a lot, which is a hostile work environment. And it's important to understand that a hostile work environment is only actionable if it is tied to a protected status. And so in this case, if you are being harassed, if you're being subjected to a hostile work environment based on your sex, sexual orientation, or gender expression, you may have a claim of discrimination under Title VII. In order to be actionable, the harassment has to be severe or pervasive. So typically one instance is not enough to have a claim. One instance may be enough if it's really bad. And it's a very fact-specific inquiry as to what's sufficient to rise to that level of severe or pervasive. There's a lot of case law out there. It's really just something that you have to kind of parse through on the facts of each case. And discrimination also includes concrete adverse employment action. So this would be you are terminated because of your protected class, you are demoted, you're not hired, you're not promoted, you're disciplined in a way that others are not, or you're transferred and others are not. You can forward the slides. So what should you do if you experience discrimination in the workplace? The first piece of advice that I give to everyone is to take really good notes. You want to document everything that happens to you, because even if it feels really impactful at the time, when you're in litigation 2 or 3 years from now, you're not necessarily going to remember exactly what someone said or exactly when they said it. So take very good notes, keep good records. You want to report the harassment internally first in most instances, unless you've already been terminated. And this is important because under Title VII, if you are being harassed by a coworker or a customer as opposed to management, your employer is not liable for that unless they know about it. So you have to kind of create a paper trail, frankly, to show that you've told somebody about it and they've failed to take any action in response to your complaints. Obviously, if you've been terminated, that's not a situation where you have to complain, because they're probably not going to do anything about it at that point. But the law considers that you have to give the employer a chance to fix the situation before they can be liable. However, if it is your supervisor who is discriminating against you, then the employer can be liable even if you don't complain about it. You do not have to report harassment to the perpetrator. So if there's a policy that says that you're supposed to report to your supervisor, but it's your supervisor who's doing the harassing, you don't have to report to them. You can go higher up, you can go to HR, you can report to someone else. And you're going to want to check your employee handbook or whatever harassment policy your employer has, and make sure that you are following that. If they've set forth a specific procedure for reporting, you want to try to follow that. And then if you're unsuccessful with reporting internally, if that doesn't fix the situation, then you want to file a charge of discrimination with the U.S. Equal Employment Opportunity Commission. That is the federal agency that is responsible for enforcing Title VII. So you have to do that within 300 days of when the discriminatory action occurs. And 300 days is just shy of 10 months. And you can do that without a lawyer. The system is designed so that you don't have to have a lawyer to file a charge. What will happen if you don't have a lawyer is that you will go onto the EEOC website, you'll fill out a complaint questionnaire, and the EEOC will schedule an appointment to interview you. They'll have an intake person interview you. And then based on that interview, they will write up a charge of discrimination for you. And they'll send it to you to sign, and then they will file it on your behalf. The downside to that process is that it can take a really long time because the EEOC is very busy. I will say, particularly in Virginia, it seems like they're extra busy. I don't know why. Tennessee seems to move a little bit faster than Virginia. But I hear frequently from people that they aren't getting the appointment for months. So just know that it's really best not to wait until close to that 300 days. You want to take action as soon as you can because it could take you quite a while to actually get an appointment with the EEOC. The other way to do it is just to do it with a lawyer. So if you have a lawyer representing you, you bypass the entire questionnaire and interview process, and the lawyer can just write up a charge of discrimination for you and file it directly with the EEOC. Autumn, you can advance the slides. So what does the EEOC process look like? Oftentimes, the EEOC will start out by offering both parties the opportunity to go to mediation. This is not required. It's completely voluntary. But if both the employer and the employee agree to it, then the EEOC will assign a neutral mediator to try to help the parties negotiate some sort of a settlement. And that'll look different depending on whether the employee is still employed or not. It may include things like reinstatement or reassignment, or it just may be a monetary settlement. If the parties either don't agree to mediation or if mediation is unsuccessful, then the case gets kicked over to the enforcement division of the EEOC and they begin an investigation. And typically that looks like the EEOC will request what's called a position statement from the employer, which is essentially the employer's response to the charge of discrimination that was filed. And then the employee gets a copy of that and the employee can submit a rebuttal. And that can include witness statements, emails, text messages, recordings, whatever evidence that you have that you want to submit. And then the EEOC can choose to conduct its own witness interviews. It can issue subpoenas. It can take any other investigative steps that it wishes to take. And it may issue a finding that there was discrimination, or what more often happens is that it will just close its investigation at some point and say, we are not going to pursue this any further. We frankly don't have the resources to investigate, but here is a letter giving you the right to go to court. That's what we call a notice of right to sue. And that is what happens in most cases. Like many federal agencies, the EEOC is overworked and understaffed. And so as much as we would love for them to take action on every case, they just don't have the resources to do that. So most often they will just issue that notice of right to sue, and then that will allow you to go to court. If the EEOC does find discrimination, it then has the power to try to negotiate directly with the employer through a process called conciliation. And that's where the EEOC tries to reach a settlement on your behalf. And then if that fails, the EEOC can actually file a lawsuit in court on your behalf. So the EEOC would be the party to the case, but anything that they recover would go to you. Next slide, please. So timeline considerations for the EEOC. You cannot file suit in court until you go through the EEOC process and get that notice of right to sue. If it's taking them a long time to issue that notice and you really want to move forward, then you can actually request that they stop their investigation and just issue the notice, and they will do that. But you have to get that notice of right to sue before you can go to court. Once you receive the notice of right to sue, things start to move very quickly. You only have 90 days at that point to file your lawsuit in federal court. So if you have not had a lawyer during the EEOC process, it can be really difficult to find an attorney to take on your case within that 90-day period, because it sounds like a long time, but for lawyers, 90 days take on a new client and get up to speed and file a lawsuit is not really a very long time. So this is one time when it really does have an advantage to have an attorney. And then the full court process, once you file, can take 2 to 3 years. And it's sort of beyond the scope of this presentation to get into the details of what the court process looks like. But just know it can be a long battle to get to the close of the court process. So what can you get if you win a Title VII lawsuit? First and foremost, you can get your lost wages. So if you were terminated or if you were forced to resign, you can get the pay that you lost up until the date of judgment and the value of any benefits that you lost. Any earnings that you've gotten in the interim, if you got another job, those would be subtracted from your back pay. And then there is the possibility of also getting future lost wages and benefits. This is called front pay. If you're still not employed at the time of the judgment or jury verdict, then you can ask the judge to award you more money to cover your lost wages in the future until you can find another job. You can also get damages for non-monetary losses. This would be emotional distress damages, mental anguish. These are capped under the law depending on the size of the employer. So the most you can ever get is $300,000. But if you have a smaller employer, you might only get $50,000. And then there's kind of a sliding scale in between those two numbers. You can get interest back to the date of your termination. You can get your attorney's fees and your litigation costs covered by the opposing party. And in some circumstances, you can get an injunction. An injunction is where the court orders the employer to do something. You are not entitled to have the wrongdoer fired. This is something that people ask me a lot. I ask them what they're looking for in a lawsuit, and they say, I want this person to be fired. That's not something that the law affords, unfortunately. It may happen, but it's not something we can ask for. Tennessee's Human Rights Act is Tennessee's version of Title VII, and this applies to smaller employers. This applies to employers who may not have 15 employees, but they have at least 8 employees. However, unfortunately, the Tennessee Human Rights Act does not include sexual orientation and gender expression or identity in the definition of sex. So therefore, the Tennessee Human Rights Act does not prohibit discrimination based on sexual orientation or gender identity. It does cover most of the other protected classes that Title VII covers, like race, national origin, religion, and so on, but it does not cover sexual orientation or gender identity. But if you're in Tennessee and your employer has at least 15 employees, then you're still covered under Title VII. And the Virginia Human Rights Act is Virginia's version of Title VII. The Virginia Human Rights Act is actually better than federal law. It applies to employers who have 6 or more employees, and it does prohibit discrimination based on sexual orientation and gender identity. So if you work for a smaller employer in Virginia, you do have rights under state law. To invoke the Virginia Human Rights Act, you file a charge of discrimination with the Virginia Attorney General's Office of Civil Rights. And it's similar to the EEOC process. You actually can, there's something called a work sharing agreement. So you actually can file with the EEOC. And if you have a smaller employer, they will just kick it over to the Civil Rights Office. So you don't really have to worry about filing with the wrong office. Again, you have to do this within 300 days of when the discriminatory act occurred. And if it's an ongoing harassment situation, you can pull all of those harassing events into kind of one course of conduct to get within that 300 days. And then the great thing about the Virginia Human Rights Act is that there are no caps on emotional distress damages. So that $300,000 limit that we saw under federal law does not apply in Tennessee, which is great. It's a much more of a deterrent, particularly to larger employers, to know that they may have to pay potentially unlimited emotional distress damages. So this is my contact information. I know we went through all that fairly quickly. It's a complex area of the law. If you have any questions, feel free to reach out to our office, and you can also follow me on social media for more information.
All right. Hello, I am Emily Calla. I am an attorney at Legal Aid of East Tennessee in our eviction prevention office, where we handle mostly housing matters, a lot of evictions, but some fair housing work. So I'm going to talk to you about what the Fair Housing Act is broadly and kind of what protections you have under that. So, whoops, I'm not sure why it's not all showing up on the slide, but the 7 protected classes are race, color, national origin, religion, sex, which includes gender identity and sexual orientation, familial status, and then disability, which has a lower threshold than Social Security disability. So if you've been denied Social Security disability, but you still believe that you're disabled, then you're still protected. And then these are the markets that are covered. So the Fair Housing Act, since it is a federal statute, it is very broad, and it doesn't actually just cover renting. It covers basically anything that involves housing. So, the process of getting a rental or purchasing a home, which would include, lending, insurance, publishing and advertising for rentals or for homes for sale, zoning, codes enforcement, anything really related to residential housing is covered under the Fair Housing Act. However, there are a few categories of people that do not have the protections under the Fair Housing Act, which includes sex offenders, those engaging in the illegal use of controlled substances currently, and anybody whose tenancy or actions would constitute a direct threat to the health and safety of the other individuals who are renting. And so that's something that I'll talk about a little bit later, but really that's kind of a balancing act. As far as I'm concerned, not every person who has, committed some kind of disruptive action necessarily is not protected. It just depends, on if this comes from some kind of disability, which does include mental illness. So I'll discuss that later, but that's kind of a more broad exclusion that is kind of up for debate. As far as properties go that are not covered by the Fair Housing Act, that would be owner-occupied buildings with 4 units or less. So if your landlord lives in your building, let's say you're renting a duplex, there's just 2 units, then generally, as the other tenant, you are not covered under the Fair Housing Act, unless they are advertising the property in some kind of discriminatory way, no children, for example. If they accept any kind of voucher assistance, then they open themselves up to the Fair Housing Act. And if they have a property management company that manages more than 4 units, then that property management company is still open to the Fair Housing Act. So some things that you might hear in relation to the Fair Housing Act that have to do with renting are reasonable accommodation requests, reasonable modification requests, and the Violence Against Women Act, also known as VAWA. So I am going to talk a little bit about those. I would say the most common thing that you hear is a reasonable accommodation request with regard to rented housing. And basically what this is it's a request that a tenant makes to a landlord to change their normal policies or procedures so that a disabled tenant may enjoy his or her residence equally to how a non-disabled tenant does. And a disability is really broad. It can be a mental illness, it can be a physical disability, it can be, something like you get a disability check, it comes on the 2nd Wednesday of the month, or an SSI check, and that makes your rent late every month, so then you get a late fee. You could try to accommodate that to not have the late fee charge because it's because of your disability that you get the check. And basically this kind of ties into that 3rd exception I talked about earlier, where the landlord must weigh the reasonability of the request with things like the health and safety of other tenants and the financial burden to them. So, that is something that varies widely on a case-by-case basis, but just know that if you're making a reasonable accommodation request, you can make it in any way, shape, or form. You don't have to mention the Fair Housing Act. You just have to say, I'm having trouble walking around in my 2-story apartment. Could I please end my lease early and get transferred to a first floor, something like that. And a landlord is supposed to recognize this is the Fair Housing Act. This is a federal statute. It covers, you know, units everywhere in the whole country. So, so another common issue is within reasonable accommodations are assistance animals, because a lot of landlords and people have kind of a misconception that service animals and support animals are, you know, different than they are. So service animals, in its very strict definition, are trained to do a task for a person with a disability, and it is a dog or miniature horse only. Whereas the more common assistance animal that we're used to now is a support animal or emotional support animal, where the animal's presence can help alleviate symptoms of any disability, you know, anxiety, depression, PTSD, insomnia, things like that. And there is a lot broader of a range of what animals you can have there, but it cannot be something unique unless you could show that you need that specific animal. I know we've had some crazy things that we've seen in Knox County. We've seen monkeys, snakes, things like that. That's generally not allowed by the Fair Housing Act. And just something that I like to bring up in every presentation is that there is a huge market for scamming people with regard to certifying their support animals. You should not be able to just go online and pay for a certificate that does not make them certified. That's not actually proper under the law. And in Tennessee, they just recently added a part of the statute that punishes a tenant for, you know, lying about an animal being an actual support animal. So just make sure that you're actually going to an actual doctor who is writing you a letter stating that you need this animal. Even some case managers that I work with didn't know this, and they were having clients go to a specific website, like the cheapest one they could find. So make sure that if you're going to do this, that you're doing it properly so that you don't get in trouble. So I kind of touched on this earlier, but service animals and support animals are protected in the same way under the Fair Housing Act, and this is just in housing, it's not in public. You cannot be charged pet rent, a deposit, or have a breed restriction on an assistance animal, but if, you know, the assistance animal damages the unit or misbehaves, if it starts biting people, then there is a problem, and the Fair Housing Act doesn't automatically cover you there. I'm ready. Okay. So the next big category is reasonable modifications. Again, this does, you know, specifically apply to the protected class of disability, but it's just a request to physically alter your residence, something like adding a ramp, installing grab bars into the shower. The payment responsibility is usually on the tenant, unless it's somewhere like a subsidized housing complex where, you know, they generally have a lot of disabled tenants, so they may decide, I'm going to pay for this so that I can keep it here and I can use it to my benefit to help other tenants in the future. And it's possible that the landlord may ask for these things to be removed at move out, but it really just depends. So. Also under the Fair Housing Act is the Violence Against Women Act. That it's, again, it's federal, not state specific, and it protects anybody regardless of their sexual orientation or gender identity, even though it says women in the title, though it only applies to tenants living in subsidized properties. So it basically just says that there can be no adverse actions taken against a tenant by the landlord for anything that stems from domestic violence, dating violence, stalking, or sexual assault. We interpret this pretty broadly. You know, if the police are called, let's say, and the landlord says there was a disturbance because it was the middle of the night and other tenants' quiet enjoyment was, you know, interrupted. If our client is the tenant and they are the victim of domestic violence in this situation, then they're not going to be able to get evicted for that. That's a very simple application, but it allows you to, you know, split a lease up to where the person who's perpetrating any of these actions has to move out. It allows somebody, if they're feeling unsafe, to move out early without a penalty, things like that. So this is really broad, and the important thing to distinguish this from Tennessee specifically is that you don't need to have an order of protection to avail yourself of these rights. Whereas in Tennessee, which I'll talk about a little later, but there's a statute and it does require a domestic violence victim to have an order of protection in order to be state protected. So this is really great, and it's great that it is overarching. Alexis already talked a little bit about the Tennessee Human Rights Act. It also covers housing in addition to employment. It's very similar to the Federal Fair Housing Act. Really, it just uses some different language. The Tennessee Human Rights Act has an 8th protected class, creed, which is a deeply held belief. I have yet to find a case that I've been able to use that on, but it's just an additional protection. And under the Tennessee Human Rights Act, the protected class of sex is limited to sex at birth. And so that's why if you are, going to look for the more expansive definition for discrimination, you're going to want to go under the Fair Housing Act. So if you think that you're having a fair housing issue, the first thing to do would be to decide if you want to have a lawyer. Most offices in my experience have this as a really high priority, fair housing issues. And I think all 3 legal aids in Tennessee definitely have grants for this specifically. With or without a lawyer, you could file a state or federal discrimination complaint, which is really easy. You work with an investigator, and they're used to working with people that are unrepresented, so you don't need a lawyer. You could do that. And just make sure that you keep everything in writing. If you have, let's say, an in-person interaction in Tennessee, it's a one-party recording state unless you're on private property. And there's a sign saying that you can't record. So record conversations, with your landlord, anything, take screenshots, do what you need to, because that will help you so much in the process of making a complaint. And then this is recorded, so you'll have this, but you could either make a complaint to the Tennessee Human Rights Commission or to HUD. They obviously they've got different statutes of limitation. HUD has a little bit longer one, and what I've found is that anything that is not covered under the Tennessee Human Rights Act, they will bump those complaints to HUD, but anything that is covered under the Tennessee Human Rights Act will get bumped there. So it's always best to do it as quickly as you can, but you really have nothing to lose. It's a very short application. If you're within 365 and you want to report to HUD and see if they would take it, it's worth it. And again, anything that has to do with sexual orientation or gender identity needs to go under a HUD complaint, and anything that is a violation of VAWA also needs to go as a HUD complaint. And then here is contact information for all 3 of the legal services organizations in Tennessee, West, Middle, and East. These, are the best places to start if you have questions, need advice on anything in Tennessee, just to see if you qualify. And if you don't, you'll usually get a referral and you can go from there. Thank you.
Thanks, Emily. Great fair housing information, and I'll tag on to that. First, I want to tell folks a little bit about the Tennessee Fair Housing Council. So we focus solely on fair housing issues, so we don't handle other legal issues, and we provide a variety of services, including legal representation, education outreach, intake. We do intake and education outreach across the state of Tennessee. Most of our case services are focused on the Middle Tennessee area, but we do sometimes take cases out of that area. And what I usually say is, reach out to us. If we can't help you, we'll certainly get you to one of the other organizations in Tennessee. that handle these issues. Unlike Emily's organization, we don't do much eviction defense work, but we do some, and when we do, it's got to have a Fair Housing Act element to it. So some housing discrimination tied up in with the eviction defense issue. We also have a testing program, and just touch on that just a little bit. Sometimes it's not apparent that housing discrimination is occurring, and so somebody will contact us and say, I think I may have been discriminated against based on my sexual orientation or gender identity, or I may have been discriminated against based on my race, something like that. And we can actually send testers to test for that. So they could either call and give enough details that folks would pick up on the protected class, or they can go in person. And so just as an example, we might send, we might have somebody call and say, my husband and I, and it appears to be a male calling, my husband and I are looking to rent, and they may be told, hey, there's nothing available. And then we have another person call and present that as if they're a opposite sex, mixed sex couple. And they may be told the same housing provider, same day or same week, yes, we have 5 units available, so we can do those kinds of things as well. So that's just a little bit about that. We also do that kind of testing to try to confirm compliance with the Fair Housing Act. So we do those kind of tests even if we don't have a specific complaint. Emily has already covered very well, what is the Fair Housing Act? What is the Fair Housing Act 2? I'll just add this, and I think it was apparent from all the other information already provided, but it's about discrimination. So it's not about fairness, all kinds of fairness. So maybe the landlord's mean to you, that doesn't necessarily mean there's a Fair Housing Act violation. It's got to be the landlord's being mean to you because of your sexual orientation or gender identity or race or other protected class. I think we can go on to the next slide. Perfect, thank you. Emily covered the covered markets as well, but I'm just going to sit down here again because wanted to make sure that we're aware that all of these markets, people are protected from gender identity discrimination and sexual orientation discrimination in all of these markets. One of the things I've been doing Fair Housing Act work on and off for over 25 years, and one of the things I love about the Fair Housing Act is how broad it is in covering all these different markets, all these different types of housing providers. Let's go to the next slide. Whoops, that's not the next slide. Let's see if we can roll back. There should be a few other slides.
We have
the most important one that I would like to get to is one that says, we've already done protected classes. The most important one is the foundation for protection for LGBTQ people. There we go. Great. Okay, so lots of markets are protected. Lots of housing providers are protected. Those I'm not protected are covered from discrimination. But and even one of the favorites is neighbors are prohibited from discriminating based on the protected classes, including sexual orientation and gender identity. So I'm going to I'll give you some examples of those in a minute, but I wanted to talk a little bit about how did we get there, because the Fair Housing Act does not say sexual orientation and gender identity in its text. It says sex. And you heard Alexis talk a little bit about the Bostock case. And the Bostock case is an employment discrimination case where the United States Supreme Court said sex includes sexual orientation and gender identity. And then there have been some other Supreme Court cases and like cases that have held those things in the employment context. There is not a Supreme Court case that specifically holds that in the fair housing context yet. I imagine there will be at some point. But what happened after the Bostock case came down in the employment discrimination context, President Biden issued an executive order saying federal agencies that handle any kind of similar laws, similar civil rights, anti-discrimination laws, need to take a look at those and see if your agency should also be interpreting those laws to include sexual orientation and gender identity. So HUD took a look at the Fair Housing Act. It took a look at the cases out there about the Fair Housing Act, and then somebody higher up in HUD issued a memo that said, we're going to implement President Biden's executive order. We're going to interpret the Fair Housing Act to include sexual orientation and gender identity under sex. And so that's been the case since February 2021. And that is the current interpretation. It is possible, given that we're going to have an administration change very soon, that some of this interpretation could change. If you hear that something has changed in HUD's interpretation, and I don't know that it will, but if you hear that it's changed, don't be alarmed, because there's would still be lots of different arguments we could make that sexual orientation and gender identity are covered, with the biggest one being the Bostock case. There's no reason that sex should be interpreted differently in the housing context than it would be in the employment context. If something does change in HUD's interpretation, the biggest thing I think that it would change is where we might file a fair housing complaint based on sexual orientation and gender identity. Right now, it tends to be the best place to file is with HUD. If something were to change, the best place would probably become federal court. But again, that's why I'd like to encourage folks to come to Tennessee Fair Housing Council or one of the other organizations in Tennessee, including legal aid, that handle fair housing issues, so that we can kind of guide you about where might be the best place to file. Let's go to the next slide. Actually, skip that one. Keep going. Yes, let's go right to, well, actually, there should be an example slide right before that, I think. Great, perfect. All it says is examples, so I guess we didn't absolutely have to go to it, but it helps me remember where we are in the presentation. So just some examples of what does it look like for somebody to be discriminated against in housing based on sexual orientation or gender identity. And it can be things like, you know, a lesbian couple being told this house is no longer available for sale, even though there's an ad out there saying that it is available. And the next couple who walks up, you know, to talk to a realtor about it is told, oh yeah, it's still available. It could be, you know, a landlord saying, we are not going to rent to your family because you're a same-sex couple. It could be a lender not wanting to rent to someone, not wanting to lend to somebody because they're transgender, and saying that, I'm sorry, you know, I'm not gonna make a loan to you. And it could be, you know, some people use code words, but we're all gonna figure this out, right? You know, I don't agree with your lifestyle. I don't agree with your choice. Something like that, even though, at least in my opinion, it's not a choice, it's a characteristic. So those are some of the examples. The biggest examples that we have seen actually happening and affecting our clients have tended to be neighbors discriminating or harassing clients because of sexual orientation or gender identity. One case that particularly sticks in my mind is it was a gay male was living in rental housing, and his neighbor began to sexually harass him, his male neighbor. And so he complained to the landlord, who unhelpfully said to him, well, you should like that because you're gay. I don't think anybody enjoys being sexually harassed, regardless of their sexual orientation or gender identity. Also, we've seen neighbors, you know, making slurs based on gender identity and sexual orientation. Again, you know, the landlord has a responsibility certainly to take action if neighbors are harassing each other. And so typically in those kind of cases, you can file a complaint against the neighbor and also against the landlord or other housing provider if they're not taking action to do something about it. Another example that could occur, I haven't seen this yet, but I can imagine that it could occur. Homeowners associations are notorious for having kind of nitpicky rules, but in the event a homeowners association allowed flags to be flown in their community, but told a couple that they could not fly a pride flag, but you could fly a US flag or a Tennessee flag or something like that. That could be discrimination. So lots of different examples. You know, sometimes, like I said, it's not clear, but if you suspect you're being discriminated against based on sexual orientation or gender identity or any other protected class, reach out to one of our organizations and we'll try to guide you through and see if we can help out. Our contact information for Tennessee Fair Housing Council is the first one on this slide. West Tennessee Legal Services, Emily already mentioned them. And the reason I mention them here is they specifically have a fair housing project that serves the whole state of Tennessee, and they work with the other legal aids as well. I put Fair Housing Council Metropolitan Memphis on here because they're a newer fair housing organization in Tennessee, and they're like Tennessee Fair Housing Council in that they focus solely on housing discrimination. They're in the western part of the state around Memphis, and they also branch out into a few counties in the state that touch on Tennessee in other states. And then HUD, of course, is always a good place to contact for housing discrimination. Like Emily mentioned, Tennessee law does not include sexual orientation or gender identity as protected classes. So you can't file a fair housing complaint based on sexual orientation or gender identity with the Tennessee Human Rights Commission. So that's just something to keep in mind. For other protected classes, you absolutely could. And I think that's my piece of it, at least for now, though I'm happy to take questions later. I think we're up to Mike talking about Virginia law.
Hey, y'all. So my name's Mike Pruitt. I'm with Housing Opportunities Made Equal of Virginia, which is a convenient acronym for HOME. I'm going to be talking about some of the ways that Virginia's fair housing law differs, some things that might matter for y'all. And also I'm going to touch briefly on how that is going to really interplay with some of the changes we might expect or we might not be surprised to see under a new administration, a little bit of what was teed up by Marty for me. So like my peers, I'm going to begin by just introducing a little bit of what HOME does. We are a civil rights fair housing organization. The only thing we do is housing discrimination. We do get at the problem of housing discrimination and these systematic barriers, though, through a lot of different angles, as we'll talk about on the next slide. But fundamentally, what we're always doing is we're trying to identify and break down different systematic barriers to equal access to housing. There's really three main buckets that we use to kind of get at that problem. The first is kind of my bailiwick. That is enforcement and investigation. This is working with intakes, doing the litigation, doing the legwork, shepherding these administrative complaints, and doing what we'll talk about in a little bit, so the fair housing testing elements. That's all under enforcement and investigation. We also have a pretty robust housing counseling and education practice. This helps people who are trying to seek out home ownership for the first time, people who are facing foreclosure, people who need to understand a little bit more about their own finances. And really importantly, we help people who are receiving different kinds of federal subsidies. We help them understand how to better make use of those subsidies, how to identify higher opportunity neighborhoods, how to use the advantages that the government is giving them, the benefits the government is giving them, and really for them. For reasons that are kind of arcane and legal, I should also just mention that this really helps play into our ability to do our legal work. The fact that we have this ongoing kind of counseling and shepherding process that we do really helps us do much more robust litigation because it improves what we call standing in a lot of areas of Virginia. If there's questions on that, I'd be happy to address that. But honestly, it's a little arcane and could get a little boring for a lot of the people here because it's going to affect us, but not you as much. And lastly, we have an arm that just does policy and research. You know, there are continued holes in how we protect people to ensure that they have equal access to housing. We've already touched on some that we know exist for LGBT and queer people in Tennessee. We see those same kind of issues in Virginia, even though we do have a few more protections. And there's always new things on the rise. Right now, I am helping a delegate in the General Assembly do some more to protect people against algorithmic price collusion, a series of words that I think 10 years ago, no one was really even thinking would ever be next to each other in a sentence. But now it's a really critical issue. If we could go to the next slide. So we kind of set this up already, but Virginia's housing law is a little bit more robust than the ones we've talked about. And the main difference that you need to understand is that Virginia just has more protected classes. So there's two that we've had for a bit, and that is elderliness and military status. So people who are over 55 are protected from discrimination based on their elderliness. And also Virginia, you know, we have a very significant military population. We have the single largest military base in the country in Norfolk in the Hampton Roads area. We actually do see some discrimination against people because they're in the military in housing. We don't want these young guys who are going to come in and mess up our house. We don't want to rent to military people. So those have been around for a little longer. The other ones are all recently added as part of we had a Democratic trifecta in the House for a little bit right before the turn of the decade, and we implemented a lot of new protections. So importantly, we have sexual orientation and gender identity protection that we'll play in a little bit in a second to how that actually makes it different than the Fair Housing Act, but this has already been alluded to. The ability to go through administrative complaint processes is a little bit more robust because that is added under the Virginia Fair Housing Act. Also, it just makes it slightly easier to write my legal briefs. I don't have to cite Bostock. I can just write down, hey, it's protected in the statute. And lastly, and importantly, source of funds is protected. And I'll get into that in a little bit, but this basically means that if you receive things other than normal income that you use to pay your rent, then that is going to not be a basis on which someone can deny you housing. Because we take intakes from the public, we actually have a really good sense of kind of what the environment of discrimination in Virginia looks like. So based on a data set of a little over 1,200 complaints that we've received from members of the public, we're able to identify what some of the more common and what some of the less common forms of discrimination. So we know, and it probably isn't surprising after you learn kind of about the growing use of emotional support animals and also the increasing challenges from that. Disability is the single largest complaint we get. We get it very frequently. It also is very common amongst elderly people because there's also some kind of additional disability concern that they're dealing with. The second most common, though, may be a little surprising if you've not thought about this form of discrimination before, and that's source of funds. So this new protection is really important for a lot of people. And next, of course, is race. Race is pervasive. It's not always the easiest to prove, but it's something that definitely people are still experiencing and bringing to us routinely. Now, these are some of our less commonly used. These are the three rarest, and because these are all under 2%, I've just provided the number of individual complaints that we've received over the last 5 years out of that data set of about 1,200. So grouping sexuality and gender identity together, an unfortunate part of how we did this data analysis, we've received 22. That's a little under 2% of our total complaints have been on the basis of sexuality and gender identity. So sometimes you will have people ask, well, does this even happen? Are people discriminating against people because of their sexuality? It does. It does. And it happens more commonly than some other forms of discrimination. Military status is not as common, even though we do see it. And I can describe, if you're interested, what that looks like. It is not as common. And the least common that we see is religion. Next, please. So I want to just dig in very briefly on source of funds. This doesn't directly touch on LGBT identity issues, but it is important and it affects a huge cross-section of America. This is mainly designed to protect people who receive housing choice vouchers, which you also might have heard called Section 8 vouchers. This is kind of a portable subsidy that an individual receives. And frankly, it creates a few additional obligations on a landlord. So landlords historically have hated taking Section 8 vouchers, which has made it very hard for these poor people, these very vulnerable people who have to rely on that to pay their rent, are often not able to find places to live. So this made it so that it's illegal to discriminate against people just because they're receiving these kinds of government subsidies. The universe of what it can apply to is actually quite large. This includes, for example, I went to law school while receiving the post September 11th GI Bill as a military veteran. I paid my mortgage with the GI Bill. If I had been trying to rent and anyone had been trying to deny me based on the type of income I would be receiving, that would be something that could be challenged. Sometimes we see this with students in other capacities, people who have maybe a trust fund, not a common target of housing discrimination you might think of, but that is also a form of sources funds discrimination. Lastly, it just bears mention, you might sometimes hear that, oh, well, they'll just have a 3 times income limit. There's actually a fairly complicated rule to interpret, but that still shouldn't prevent people from being able to make use of the source of funds discrimination protection. They are only supposed to be looking at the portion of rents that the tenant would be responsible for paying. So the housing voucher would pay most of their rent, but the small portion that the tenant has to be responsible for, that is the only piece that they're allowed to analyze for the purposes of income qualifications. And so if you're receiving a housing voucher, you will almost always qualify based on an income limitation, unless the landlord is trying to break the law. Next, please. So this is important because this is going to really play into some of the differences in the Virginia process. There's two different places that you can file a fair housing complaint, and that is true for sex and sexual, for sexuality-based complaints and for gender identity and like trans-based discrimination. So we can file in the Virginia Fair Housing Office, and frankly, it's much faster normally. That being said, we do have a Republican Attorney General right now, and there is a little bit of docket control. So it will sometimes see more frequent dismissals of claims. You can always still file with HUD. Sometimes they will just punt right back over to the Virginia Fair Housing Office. But probably most importantly, you should just come talk to us, because we will help you think through the strategic question of which one to file with. In 2 localities in the Commonwealth, you can currently even file with your own locality. So it's a complicated set of thoughts, and we would always be happy to help you think through that and to process a complaint. Next. The complaint process, we've already talked through this a little bit, but basically it begins with this very simple form that you can fill out using your own words. If you don't want to use your own words or you're afraid of misspeaking, we're always willing to help Housing Opportunities Made Equal review your complaint and see if you've actually got a good claim. Then it goes to mediation. Basically, the Fair Housing Board receives it, and they immediately say, hey, do y'all want to just sort this out? We'll put someone in the room and help you figure it out. This is often actually what we're trying to get to, right? Because people just want to get into their home, or they just want to stop being the target of discrimination. They want to keep their emotional support in. So realistically, the goal of a complaint is often just to get to this and settle the matter. If it doesn't get settled at this time, though, there is an investigation that's launched. And this is very helpful. It develops a lot of evidence in case we do ever have to go to court. And it really kind of puts the discriminating landlord on the back foot. And next is what we call a finding, as in a finding of discrimination or no discrimination. It's important to note that also after a finding of discrimination, it's normal that there's one more opportunity for mediation. And at this point, the tenant is going to really hold all the cards, or I should say the person who has been discriminated against holds all the cards. Because if you don't come out of that mediation with a settlement, then the Attorney General of Virginia has to sue. If there's been a finding discrimination, they have to sue. So it's often very easy to settle at this juncture. I should also mention there is one kind of important line here between steps 1 and 2 of whether or not the Virginia Fair Housing Office or HUD decides that your claim is valid in the first place. And because they're trying to reduce their own workload, there's often kind of a burden of getting over that initial line. So you might sometimes see claims that seem fine get dismissed between 1 and 2 because they just don't have the resources and they want to gin up a good reason to dismiss it. Next, please. Now, let's talk very quickly about some of the changes we actually might see, right? Because I've been invited to a few different LGBT groups because, frankly, I understand folks are scared. So the most immediate threats are going to be funding. Right? We know this from some of the conversations we've heard during the confirmation hearing, some of President Trump's own statements and efforts during the previous administration of his. So while the most immediate threats would be to organizations like mine, organizations like Marty, we might see less funding available for our work that combats discrimination. So we're nervous about that. That doesn't affect the individual tenant or the individual person facing discrimination as directly. The more possibly direct way you might see the individual affected is a decrease in funding for these individual benefits that people make use of, specifically housing choice vouchers and HOPWA vouchers. HOPWA vouchers are housing opportunities for people with AIDS. It probably doesn't surprise people that a significant majority of people are on the LGBT spectrum who receive HOPWA vouchers. It's not clear whether or not we're going to see a decrease in funding. Mr. Turner, during his confirmation hearing yesterday, talked about removing barriers for the housing choice voucher for landlords, a thing we hear a lot. There wasn't a discussion about gutting that funding, but this is always something we want to keep our head on a swivel And lastly, probably the most important part of it, which we've already talked about very briefly, but this executive order that basically said HUD has to treat Bostock as the law of the land and accept complaints on that basis, right? It is very reasonable, and I would expect I frankly personally would expect that to go away pretty quickly, meaning that HUD is no longer going to be able to receive complaints based on gender identity and discrimination. That being said, you will still be able to sue under the Fair Housing Act and under the Virginia Fair Housing Act as a queer person who has been discriminated against on that basis. And you will still be able to file a complaint in Virginia, which you'll remember we already often tell people to file in Virginia. It just means you won't be able to file in HUD and you have to file in Virginia. And that's not going to change anytime soon. Next, please. And lastly, I had a little bit in here about testing, but I should just acknowledge we're coming up on time. I think I'm actually 2 minutes past time, and it's already been discussed briefly, but this is just a secret shopper. We use it to identify sometimes some hard to identify forms of housing that you really need to collect that evidence on the ground. If you want, anyone is invited to reach out to us and become a tester. There's a little URL right there, because this is a volunteer-based program. I actually can't even legally do it as an attorney. It doesn't work. So if you are interested in becoming a tester and actually helping us root out discrimination, that is something I would love to have more volunteers for. The URL's right there. And next. And that is how you can contact us. You will, if you have a complaint, you'll talk to someone in intake pretty quickly. We'll brief it and we'll figure out how to best legally help you. And I am thrilled to answer any questions that folks have.
I'll jump in again on this quick little disclaimer. This is something that Mike's organization and my organization are required to put in presentations. So some of the work, at least, that went into this presentation was funded by the U.S. Department of Housing and Urban Development. This is our content. It is not HUD's content. I'll also add, I think this is helpful for all of us as attorneys. What we just gave you was information. It's not legal advice specific to your situation. If you want the legal advice specific to your situation, contact our organizations.